Welcome to today's Global Connections program. I'm Bill Miller. Today we're going to take a look at the legal system in the United States, but also take it internationally, because what happens internationally does impact us to some degree. My guest today is an expert on this topic. Judge Thomas Moukawsher is a Connecticut complex litigation judge and former lawyer, legislator, and lobbyist. He is the author of The Common Flaw, Needless Complexity on the Courts and 50 Ways to Reduce It. Judge, welcome to today's Global Connections program.
Thank you very much for having me, Bill. I'm glad to be here.
I appreciate you being with me today. Your title sounds like a great primer on how we can reduce a lot of the clogging, if you will, of some of the courts. Let's just start out with a basic question. Why did you write this book? What was your main purpose in doing that?
Well, I've had about 40 years in the court system, 30 years in the federal courts, 10 years on the state bench, and I ended up feeling like somebody had to do it because our system absolutely depends on the rule of law, and the rule of law depends on public faith in the rule of law. And I see that faith has been diminishing because we've had this trend ever toward more expensive and less satisfying lawsuits. So I thought, we had to end the trends that we're following that are really undermining faith in our institutions. And so that's why I wrote the book. And my aim is to try to build faith ultimately in our system.
Mm-hmm. Those are two very good points. So many of these trials are lasting longer and costing more. What recommendations would you make to help reduce that to some degree, to make it more manageable from the time management and also from the financial standpoint?
Well, I've got 50 ideas. I'll hit a couple.
Okay, pick some of the major ones.
The major ones are, it starts with the way the lawsuit starts. It's a document called the complaint. They get ever longer, ever more complex when they're usually stating fairly simple problems of why some human value that's been enshrined in law has been violated. And things that could take, 4 or 5 pages are often taking 100 in just filing the lawsuit. Also, I think that there have to be fewer motions. People are constantly challenging in court these days every aspect of the lawsuit without ever addressing what the lawsuit is about. And by that, I mean, did you file it in the right court? Did you file it too soon? Did you file it too late? Are you the right person to bring the lawsuit? Is there a better court that could hear this? Did you use the right magic words in filing the complaint? All these things are often brought up in multiple different motions, challenging the court's jurisdiction, trying to throw the complaint out, and that eats up years. So ending that process and starting with a simply one single procedural motion would be another thing that I think is critical. Above all, frankly, controlling the evidence gathering process would be the biggest thing that we could save time with, and that's the process we call discovery. Most of the money of the party gets eaten up with these battles over documents and things. If judges controlled them, that wouldn't happen. Beyond that, streamline trials, prompt decisions, and decisions we can understand and read ourselves are key things.
Mm-hmm. Have you sent copies of your book to all the law schools in the country? Sounds like this is something they should incorporate, these ideas.
It's out for publication on the 25th of September.
Right.
Once it's really in print and I have lots of copies of it, that's exactly what I plan to do. I've sent out some limited copies already to some key people, but I'll have a lot more of them. And I want to get that word out there and spark a dialogue. I hope.
Exactly right. It seems like your book promotes more of a humanistic approach and a public trust approach to the legal system, and sort of defines the legal system as something that's grown and grown and grown, as sort of a gargantuan, I'm not going to say monster, but one that's more bureaucratic. Let's put it like that. Well, is that a correct summary?
Oh, it is, because that's the point. Is about what I was saying is that all those things I listed as problems, challenging where the case was brought, challenging the words it used, etc., is all about the lawsuit itself. And my argument is that a humanist approach to a lawsuit would be all about two things. One, the human values enshrined in law, and two, the humans involved in the lawsuit and its implications for them. And lawsuits today are cases about a case instead of cases about a human value, a human conflict. And that's what I'm aiming at.
That's extremely important and it's very logical, to be quite honest, most assuredly. You know, you're talking about our faith in the court system, and it seems, well, for many reasons, there have been attacks on the court system, especially the U.S. Supreme Court. Of course, that's the top court in the United States. And what can be done to restore the credibility of the U.S. Supreme Court? What do you see as some of the challenges there at this point in time?
Well, I think the biggest challenge for that institution, like all of our institutions, is people aren't willing to trust it on blind faith anymore. A trust in this country today, I think, has to be earned, and it isn't easy to get. I think the reality is, and this is just a fascinating part of it to me, is that our institutions are far more ethical and far more honest than they've ever been in the history of the country, and yet they are trusted less. People need constant proof that our institutions are performing, and the Supreme Court, I think, can remedy that by promptly adopting a code of ethics. I think they certainly need one, and they should have one, and make sure it's public, and make sure the information gets out to people as to that the fact that they're complying with it, and it will help them. And they can also start to write their opinions in ways that people can understand and read themselves, which is a major theme of my humanizing things. A lot of their opinions are real formalist opinions. You can't understand what they're saying, in short. And with a humanist approach to it, it would be intended that the public could read it and be reassured by it. So I think they should do that too.
Can judges do that in the courtroom? I'm not a legal scholar, far from it, but can a judge give direction to the plaintiff and the defendant, or whatever the case might be, to actually write in plain English, or to incorporate some of the changes that you've been making?
Well, a lot of it is training, and judges supervise lawyers. In the end, many judges go hands off on being involved with lawyers and about doing something which I think judges and a legal system can do, which is to teach good practices. And judges can do it by modeling it with the orders that they write, with the decisions that they write, and they can set page limitations, lay out specific things that they want lawyers to cover in their briefs, and ask them to do it in language that can be understood. I do it all the time. I'm often, if there's suggestions, I mean, lawyers have to make their own choices how to present their cases, but I make suggestions all the time.
Exactly. Yes. Well, this is it's a constitutional crisis we're undergoing right now for several reasons, but the one with the Supreme Court is certainly paramount, in my opinion, anyway. What role do you think Congress could play? I know that the Congress has made changes to the Supreme Court over the last several decades. So what role could they play to make sure that they do incorporate a code of ethics, a judicial code of ethics, which, as I understand it, all the judges in every court in the United States has one, except the Supreme Court?
Well, that's why they need to get one right away. You don't want to have a clash with Congress over the separation of powers. The judiciary being independent of Congress is very important in terms of its day-to-day functionings. Congress could assert itself more vigorously over the courts, but I think in some ways we'd lose out if we ended up with a primacy of the legislative over the judiciary. They should be separate and equal powers, and along with the executive branch, have some areas in which this is their primary jurisdiction. And that's why they need to act before Congress forces them.
Exactly. It's a very good point. And this may be the motivation for Chief Justice John Roberts to get a very equitable code of ethics immediately. And they could do it. They could do it very easily. It's not that difficult. It's not like reinventing the atomic bomb or something. You can do it fairly quickly.
Have them. They can just take a look and adopt one.
That's right. That's right. Well, that brings to mind adopting other pieces of legal information. I'm thinking of, I mentioned about international legal machinery, And when I think of the international legal machinery, I think of the Universal Declaration of Human Rights, drafted in 1948 by the UN General Assembly and shepherded through by Eleanor Roosevelt, the former First Lady of the United States. The International Criminal Court, located in The Hague, which was created by the UN, but is not under the UN tutelage right now, I guess you could say. And the International Court of Justice, which is the sixth organ of the United Nations. How do all of these three legal entities tie into what you're doing? I know they don't directly affect, well, I'm not going to say that. How do they tie into your legal operations?
Well, they do because it's about the rule of law. And I think that respect for the rule of law, the idea that we have a country of laws, not men, is the way it was originally expressed, and a world of laws and not people, is a vital thing to keeping a country stable. We've seen challenges to that in our country, where some people have tried to put themselves above the law. We see it in Russia. We see it in China. Russia, in particular, has shown that a country that doesn't have respect for the rule of law endangers itself. A world without institutions that show respect for the rule of law endangers itself, because then it becomes back to what we were trying to get away from when we adopted the United Nations as a mechanism for dealing with disputes, and that's war. If the only resource that you have to turn to resolve disputes is violence, then we have the world creeping backwards. And I think that there was a great deal of hope when the United Nations was formed and this Universal Rights Declaration was passed, that there'd be a hope that we'd resolve our disputes by a rule of law and not simply by force.
And even though it's more difficult today with all, especially because of primarily misinformation, various denials that take place about different aspects that are being treated at the UN, but the UN is actually much more important today than it was in 1945, and it was extremely important at the end of World War II, as we came out of the ashes of World War II, but it makes it more difficult. What role do you see for the media as far as trying to help us better understand these issues and to get away from some of this nonsensical conspiracy theoretical stuff that really is not factual? It just simply is not factual. But what role does the media play to help us better understand these issues?
Well, that's a tough one, because the media is governed by money, and money loves sensation and anxiety, and so it pushes it. But they could at least start by not mocking international institutions quite so much. The United Nations comes in for some pretty hard knocks from the American media, but it was an American idea. And so it was an American idea that people around the world have had more enthusiasm for than Americans. So the media could spend some more time helping by showing the good work that the United Nations and our other international bodies are doing. And at least if they won't showcase them, they can stop denigrating them, because they're weakening public faith in peace, is what it boils down to. And I don't think anybody can, that's not a good long-term business model for anyone to destroy the institutions that they cover.
You're absolutely right about that. The UN has many successes. It has some setbacks, no doubt about it. It's not a perfect organization, but it has had so many setbacks, and it has worked really on behalf of the majority of the countries, 193 countries at the UN, but especially for the United States. We have benefited more from UN programs, UN agencies over the years, and even today, when you look at that whole family of UN agencies that are out there. But you're absolutely correct on that. Well, you're watching Global Connections Television, which is a privately funded, independently produced program. The opinions expressed on Global Connections are solely those of the moderator and his guest. We'd invite our viewers to go to our website at www.globalconnectionstelevision.com to view previous programs. Also, if you're involved with a PBS or community access television station, or perhaps an educational institution that has an intra-campus television hookup, or you have a podcast, or you just have a computer, you like our shows, and you would like to share them, please feel free to do so. Global Connections Television is provided at no cost as a public service to help us better understand international issues and how they impact our lives. Today, we're taking a look at a very interesting book that's just hit the press, so to speak, and it's on the legal system in the United States, and it probably could be utilized in many other countries of the world. My guest is an expert on this topic. Judge Thomas Moukawsher is a Connecticut complex litigation judge and former lawyer, legislator, and lobbyist. His most recent book is The Common Flaw, Needless Complexity in the Courts and 50 Ways to Reduce It. Judge, we're talking about this very interesting book. Well, first off, I don't want to get off the UN international machinery. Do you have any other comments about that? How we really need to focus on the rule of law? And this is true in this country and worldwide. And there has certainly been a denigration of that. But do you have a closing comment on that before I move on?
It's about humanity on all levels, and that's what my book, The Common Flaw, is about, and that's what our institutions are supposed to be. Our international institutions are supposed to be focusing on human potential and building it and defending it, and that's really what I like to think my book's attempting to do here in the United States. But you're right; it also has it could also help in systems all around the world in terms of trying the truth finding process that is the legal system in most countries, at least in theory.
Exactly. We need to do that for sure. Well, there's so many other elements out there. We have so many movies that are out there that have judicial overtones where juries are making decisions and that type of thing. What role do you see for the movie industry, the cultural aspect of our society, to help us have a better understanding of the legal system and to promote some of the ideas that you're talking about, really?
Well, the movies, I think, do it better than the courtrooms sometimes. And people,
really,
lawyers will watch a movie and say, well, that's not what it's like, but it could be. And that means, in other words, that it could be interesting what goes on in court if we focus on the human values being applied to a human conflict. I mentioned a few good men in my book, The Common Flaw, and as an illustration of good cross-examination. The usual cross-examination of witnesses and the offering of documents in courts is again belabored by technicalities and formalism instead of going for the jugular of truth, which you often see in movies. And A Few Good Men's a great example of that. The Jack Nicholson standoff with Tom Cruise is magnificent, but there are many other movies that just show you actually how you could brush aside the stuff we get tangled up with and deal with a real human conflict. Witness for the Prosecution is a great British movie on the subject. There was a remake not too long ago. And there are many other American movies of the same type. Anatomy of a Murder with Jimmy Stewart's one of these great, but you can see real drama. And I think we've been choking the life out of cases in our own courts. And I with The Common Flaw, I'm trying to breathe a little life back into it. That's why I do use movies, and I have a series of cartoons that illustrate the points I'm trying to make too.
Well, I have a copy of the book, and I'm looking forward to getting into it immediately. I really am. I unfortunately haven't had a chance to. Well, I have started it, but I haven't gotten well into it. We talked about the Supreme Court and how the credibility of the Supreme Court is collapsing, to be quite honest, because of some of the alleged charges against some of the justices, Justice Clarence Thomas, Justice Alito, and some of the others. But we also have a situation, a constitutional crisis with the January 6th insurrection to overthrow a free and fair election and to install a person who was not elected president of the United States back in 2020. How would your book tie into this? Do you have any just general observations on that situation, or how would your book tie into where we are? There are 4 indictments right now going on against former President Donald Trump, but how would that come together?
Well, the ideas in the common flaw would be aimed at seeing that we're not where we are right now, which is litigating the last election while we're facing the next election coming right at us. In short, these issues should have been wrapped up a couple of years ago. And if the courts function more efficiently, if the judicial system, the justice system functions more efficiently, this could be behind us. Now, I will say that there were those 32 lawsuits that were filed during the election itself in its immediate aftermath, and the judiciary should be credited with having dealt with them swiftly enough to try to get it behind us. But had the Supreme Court made itself present during that process and had taken decisive action, we probably wouldn't have had January 6th happen either, because the Supreme Court of the United States would have brought finality to those challenges. And I know that it's once bitten, twice shy, and they don't want another Bush versus Gore, but you don't wait till it's too late just because maybe once before you acted too soon. And I think the court could have played a better role, but more important, an efficient judicial system could have had this all wrapped up by now and should attempt to wrap it up as soon as possible.
And there have been just a whole series of delays, one delay after another, challenging this, challenging that. And it really is not expedient to move these cases forward. But are we not required in this country to provide a timely trial for the participants and for the general public too?
Well, legally speaking, it's a question of due process, and the ultimate measure of due process is a timely and fair hearing. And so, if justice delayed is justice denied in many cases, and that's happening all the time in the courts. Is what happens is that the case takes so long to get decided that the problem it was addressing is already behind us so far, and so I think that's the thing we need to fix. And I think that judges need to deal with preliminary challenges faster, because that's how you tie a case up into knots. You've challenged this, you've challenged that. All procedural and function-oriented challenges that prevent you from getting to trial. And so judges challenged by that in this particular time need to get those things addressed, get them addressed efficiently, maybe to address all the questions at once, and then move in the jugular of the actual case. And so it's going to take some work, and there are going to be many attempts, I think, in lots of the cases pending to try to hold things up.
There certainly are. No doubt about that. That's for sure. Well, let me ask you in our closing minute or so, do you have any other suggestions you'd like to share with our viewers, or any other insight into the legal system, either in the United States or someplace else in the world, perhaps?
Well, I think the most important message I'm trying to get across in the common flaw is that we need to put humanity first in what we do. And much of what we get trained in law school and in life is about process. It's about form over substance. And I think we need to understand and get in touch with the core human values that animate our legal system, and to apply those to real human problems and give an answer that people can have faith in and can also understand themselves. And so that's the message I want to get across most in the common flaw and in our chat today.
And of course, so many of these issues, almost all of them, I would imagine, are covered in your book, The Common Flaw, Needless Complexity in the Courts and 50 Ways to Reduce It. And it's a primer for law schools, for attorneys, for judges, for legal systems in this country, and again, I think worldwide, because we are actually undergoing some of the same problems that really have been going on overseas for many years. We're having them here in the United States, especially with the weakening of the courts, casting aspersions on the legality of the courts, their credibility, and that type of thing. But this is something that we really need to work on. But Judge Thomas Moukawsher, I want to congratulate you on a very interesting book to start off with, and to thank you so very much for a very interesting and a very informative program.
Well, thank you very much for having me. I enjoyed being here.
Thank you. My pleasure. I'm Bill Miller. Thank you for joining us today on Global Connections Television.